Hi, my name is Larry Studer, and I am one of the probate attorneys at Private Corporate Counsel, a Florida law firm. If you are watching this video, it likely means that someone you love was affected by the toxic water found at Camp Lejeune and has since passed away. The highly contaminated water levels at Camp Lejeune affected nearly 1 million servicemen, their families, and other civilians stationed or working at Camp Lejeune from 1953 to 1987. So it is important to note that you are not alone in what you have gone through and what you continue going through. We hope this video answers many of the questions you have concerning the claim filing process and the role of probate in the process. I presume many of the viewers of this video reached out to a law firm to initiate a claim under the Camp Lejeune Justice Act, only to find out that they needed to speak to another law firm first. Your first question was most likely something along the lines, "Isn't the law? Why do I have to speak to numerous law firms in order to file one claim?" We understand your confusion. The easiest way to explain it is to draw an analogy from the medical profession. Just as you would not speak to a podiatrist if you had a heart attack, or speak to a cardiologist to deliver your baby, you would not speak to an injury attorney for a probate matter. Essentially, the law is too vast and too complex for any one attorney to practice in every area of law. Each firm has a specialty or a group of specialists. Firms routinely work together to help clients, such as the Camp Lejeune survivors and their beneficiaries, to obtain relief by going through the various steps to effectively file their claims. As a law firm that practices probate law, our probate team specializes in opening the type of probate estate that is required in order to present a claim under the Camp Lejeune Justice Act on behalf of a decedent. Without properly opening an estate and having a personal representative name, it would be impossible to file a claim on behalf of a deceased claimant, even if you were the surviving spouse or a child of the decedent, and even if they left a last will and testament. Under the terms of the Act, an estate must be opened before a claim can be filed on behalf of the decedent. That is what we specialize in so that you can file the claim in the first place. Now that you know why a probate estate must be open, we will discuss what is needed and what to expect in the probate process. In order to initiate the probate process, our firm will need the following documents and information. First, the original last will and testament, if there is one. Second, names, addresses, and email addresses of the estate, beneficiaries, or next of kin. Third, a certified copy of the death certificate. 4, a consensus as to who will serve as the personal representative, and in some states that is known as the executor. Now there are two types of probate estates. One is a probate estate where the decedent had a last will and testament, or simply a will. The second is probate estates where the decedent died without a will. Not all cases will have a will. In fact, most cases, or about 2/3 of the cases that we've dealt with, will not have a will. However, if your loved one had a valid will, we are required by law to follow the terms of the will. For a will to be valid in Florida, it will need to satisfy the following requirements. 1, it needs to be in writing. 2, it needs to be signed by the decedent at the end of the document. 3, it needs to be witnessed by at least 2 people who also sign the document at the end. 4, it needs to be signed in the presence of one another, preferably be notarized. The court requires the filing of the original will. Copies are not sufficient and will not be accepted by the court. Most Americans pass away without a will. If your loved one falls into this category, the probate estate can still be open, but it will be open as an intestate case. Intestate is just a fancy Latin word meaning that the decedent died without a will. So if the individual you are making a claim on behalf of did not have a will, that's fine. We can still open an estate and file a claim. If a resident of the state of Florida dies without a will, the state distributes the assets based on who survived the decedent. Now the following is general rule. For example, if the claimant died with children but no spouse, then the children inherit everything. If the decedent died with a spouse but not children, then the spouse inherits everything. A spouse and children from only that spouse, and the spouse has no other children, then it depends on the year when the decedent died. If the decedent died with a spouse and children, but the spouse also has children from a different relationship, then the spouse inherits one half and the children inherit the other half. If the decedent died with a spouse and children from a prior relationship, the spouse inherits one half and the children inherit one half. If the decedent died with no spouse and no children, then the surviving parents inherit everything. And if the decedent died with no spouse, no children, and no parents, then the surviving siblings inherit everything. And that's as far as we go, because beyond that it's extremely rare. Now that you have an understanding of what a probate estate is and who the beneficiaries are, let's talk about what we need from each beneficiary. This is what we need to process the case. 1. Information on the beneficiaries. Full legal name, current mailing address, and email address. While the courts only require the name and address of each beneficiary, the email is to help us so that we can go and share documents, so the documents can be signed electronically, and so we can keep up to date with the beneficiary, all of which dramatically speeds up the probate process. If a beneficiary does not want to be involved in either the probate process or the filing of a claim under the Camp Lejeune Justice Act, they will not be required to participate. However, for fraud prevention purposes, they will need to sign paperwork before witnesses and a notary to make their intentions clear and binding before the court. If a beneficiary cannot be located but is believed to still be alive, this will seriously complicate the matter, as the case will not be able to proceed without providing the beneficiary notice. If this applies to your family, please notify us immediately. A death certificate will be required to prove that the claimant has passed away. The courts require a certified copy of the death certificate, and that will be sent to the county in which the decedent resided. Each county has slightly different requirements, and I will not be able to address all 67 counties in this video, but we check with the clerk of the court where the decedent resided to determine what they require, and then we work to provide that to them. There are two different types of death certificates in Florida, commonly known as the short form and the long form. The only difference between the two is that the long form contains the cause of death and the full Social Security number, whereas the short version omits that information. Most counties prefer the short version over the long version, and that's a better way for us to go. If you do not have a copy of the death certificate, that may be obtained directly from the county or by going to the website in the description of this video. This video will contain that website information, and you can go there to inquire about a death certificate. Now, the information about the personal representative or the executive. If there is a personal representative or an executor named in a valid will, that person has first priority to serve as the personal representative. If that person is unable or unwilling to serve, then the person named as a successor has the right to serve as personal representative. If none of the named personal representatives are able to serve as the personal representative, then a majority of the beneficiaries will have to agree on who is to serve. If there is no will, priority is given first to the surviving spouse. She has the first right to serve as personal representative, and if she does not serve, then the majority of the beneficiaries choose who will serve as personal representative. In order to serve as personal representative, the following requirements have to be met. The person has to be at least 18 years of age. The person must be mentally and physically capable of serving. The person cannot be convicted of a felony or abuse of an elderly person or a disabled adult. The person needs to be a resident of the state of Florida. And if the person is a non-resident, then the person needs to be related to the decedent by blood. Now we have submitted all the necessary information and documentation. What happens next? When all of the proper documents and the information have been obtained, we will draft the necessary court documents and send them out for the necessary signatures from the relevant parties. Most of the signatures can be obtained electronically, and you can use any smart device to sign it so that you don't need to print, scan, fax, or mail the signed documents. For the personal representative, there is a need for a few forms to be signed and notarized before a U.S. notary. Any U.S. notary will work, and most individuals can get free access to a notary at their place of business or their bank. Now, after all the paperwork is signed and returned from the personal representative and the beneficiaries, our firm will file the forms with the court. While each Florida court varies depending on the number of judges assigned and the case inventory, the promptness of the clerks, the availability of hearings, on average, we receive the court orders back within 2 to 4 weeks after we submit all required documents. As soon as the court orders are obtained, we will request that the court orders be issued as certified copies. We request that from the clerk's office. By certifying the court orders, it legitimizes to third parties that these are valid court orders, and they will be accepted as valid court orders. Once the certified court orders are received, the personal representative will be able to obtain an EIN number, that's a tax number, and then can open a bank account under the name of the estate. This will be necessary once the settlement checks are made and issued so that they can be deposited into the estate account and then distributed. An estate account can be opened at a bank or a credit union of the personal representative's choosing. It's always best to make sure it's an insured account. If you do not know how to obtain an EIN number, you can go online at the IRS website and they have instructions on how to do that, or you can ask your tax advisor for assistance. After we obtain these certified copies of the court orders, we will provide these to the Keller Postman firm. At that point, they will have what they need to file the claim on behalf of the decedent. At that point, there will be little for us to do the estate. However, Florida law requires estates to be completed in a year. If the claim is not resolved within a year, we will need to ask the court for an extension of time in which to close the estate. We will notate on our calendar a reminder to file a request for extension of time if the claim is not resolved within 11 months. Now, once the settlement of the claim under the Camp Lejeune Justice Act has been made, the funds can be dispersed to the beneficiaries, and the estate account can be closed, and the probate estate can also be closed. You may have additional questions or concerns. Our office can provide virtual consultations at various times so that you may have your questions answered. We do this virtually so that you can attend with minimal interference with your schedule. To sign up for one of our virtual seminars, you can use a link that can be provided by the firm. We look forward to working with you on this matter.